My name is Maria Carr. I'm at McDonald Hopkins, and I'm joined today by Matt Christensen at Johnson May, Robert Glantz at Muse Shellist, and Evan Hill at Skadden. We're here today for the third installment of the Nuts and Bolts series by Financial Foys. And today we'll be talking about the nuts and bolts of DIP financing. Before we get started today, I have information from a couple of our sponsors. First is the National Law Review, which is a premier legal news website offering in-depth analysis. And then our second sponsor today is Max Asset, which is an online sale platform for single asset sales online. Just a disclaimer that while each of us are attorneys, this is not legal advice. This is just information for general education, and we are not your attorneys. If you have any questions about anything that we discussed today, any of us are happy to discuss it with you separately. So with that, we'll dig in here. So today we're going to discuss the two ways that a Chapter 11 debtor can fund its operations during a bankruptcy case. And that's through using cash in post-petition operations, which is like generally the collateral of a secured lender, or obtaining new debt financing to fund its operations. And once a company files for bankruptcy, either of these situations requires court approval. So Matt, can you start us off by explaining the difference between these two options?
Sure. So the first option, just your normal operating income. This is exactly what it sounds like. You've got sufficient operating income to keep the operation funded moving forward. Maybe there's some creditors with liens on that cash, and so there's a cash collateral order or motion you have to file and an order you get obtained, but it's basically you're moving forward with the operating income that you have, and that's sufficient to keep your operation going, at least pending a plan being confirmed. The second option, the debtor-in-possession financing, this is borrowing. This is borrowing additional funds to help pay operating expenses, or maybe there's some other expenses that need to be paid in order to keep operating. And there's different forms of it, which of course is what the next hour is going to be discussing, but it is basically new money. You're borrowing new funds from some source in order to keep going.
Thanks, Matt. And what's more often seen in Chapter 11 bankruptcy cases, just cash collateral or DIP financing, or both?
I think the debtor's preference is to not have to borrow more money. So if you've got enough cash flow income coming in and not so many creditors with liens on that you're otherwise having to pay so much inadequate protection payments that you can't keep operating, that the preference from the debtor standpoint is just use my operating income. Borrowing additional funds, of course, just adds to the stack of creditors you've got to deal with in the bankruptcy case, and potentially makes it even harder to get a plan confirmed because of the timing of repaying most of that DIP financing. So more often, I think you see just that general cash flow use, but it's often enough that you'll see the debtor-in-possession financing too. I will say most of the time, if there's a debtor-in-possession financing, there's also ongoing cash collateral use too. I think it's more rare that you would see just DIP financing as the only source of income during the bankruptcy period.
Yeah, agreed. Rarely do we see a company enter bankruptcy without any secured lenders at all. So Robert, usually in a Chapter 11 case, we see either cash collateral or DIP financing motion, or a motion requesting authority for using both, filed right at the outset of a case. And why is that so? Why are these motions so important?
Well, it's mainly they're important because the code tells you basically you can't use cash without permission. And while it does provide that, it doesn't necessarily say, what's going to happen if you do. But I think it's pretty fair to say that you're likely going to be hit with a motion to dismiss the case by multiple creditors and the U.S. trustee and what have you. So again, it's what you have to do because the code tells you so.
Yeah, and I guess, often with all the other first day motions that are typically filed, they're requesting authority to pay various types of obligations, and you need money to pay it from somewhere. Usually your secured creditor, I guess.
Right.
So Evan, let's go right into the cash collateral concept a little bit more. So what does a company typically need to demonstrate to get court approval for the use of cash collateral, and what is adequate protection generally?
Sure. So when we think about cash collateral, it's a similar general principle that applies to other types of collateral as well, right? And think about kind of what the automatic stay does and what is it for, right? It gives the debtor a breathing spell, an opportunity to ensure that creditors aren't seeking to enforce remedies. So when you think about cash collateral, you're precluding your secured creditor who has liens on that cash from taking it. But in exchange for that, the code provides that that secured creditor is entitled to protection, right? And so the term of art is adequate protection. So the estate needs to provide adequate protection to the secured creditor in exchange for, preventing the secured creditor from seizing cash and also for using the cash, right? So it's adequate protection. And what is it adequate protection of? It's adequate protection of the diminution in value of the secured creditor's interest in the collateral, right? So more terms of art, that's kind of really what it is. It's a measurement of over the course of the case, starting really from the petition date going forward to when the collateral is ultimately either disposed of or released back to the secured creditor. How does the value of the collateral change, right? And if it decreases, and you measure that decrease in value, there's at least the potential that adequate protection would need to be provided to the secured creditor. So I would maybe just use two kind of examples, right? So you can kind of visualize how this measurement would work, right? So first example, let's talk about an oversecured creditor, right? And let's think about, just as an example, let's say the collateral is worth $100. Let's say the secured claim is in the amount of $60, right? So the secured creditor is $40 million oversecured. So even if during the case, the value of the collateral goes down from $100 to $80, if the secured creditor's claim is only $60, it's fine, right? There's no diminution in its value in the collateral. So in that instance, in that example, you wouldn't need to demonstrate adequate protection because the creditor is already adequately protected. But flip the numbers around, and let's use an example where the collateral is worth $60 and the claim is $100. Now we're dealing with an undersecured creditor. So starting from that point in time going forward, if the value of the collateral decreases from $60 to $40, that's a $20 difference, diminution in value. Now we've kind of identified a hole that would need to be plugged in a manner that demonstrates adequate protection to the secured creditor. So just kind of conceptually, at least how I think about adequate protection and diminution of value. So those are pretty simple examples. Obviously, it will become much more complex in terms of identifying what the value is of collateral on day one and what it might be in the future to measure that adequate protection. But that's high level in terms of how I would look at it.
Great, thanks. And then how have you seen courts determine like what the appropriate adequate protection would be, like in terms of how determining value or what the risk to the collateral is? I know it varies case by case.
Yeah, it certainly does. And it varies in terms of really two things primarily in my mind. Number one, what is the asset, right? And so here we're talking about cash collateral in particular, but that's almost always tied to some sort of operating asset that also serves as collateral to the same creditor. So it's an operating asset that's presumably throwing off cash over the course of the case. Or if it's not, if it's a hard asset, well, what is the ultimate destination going to be for that hard asset? Will it be monetized in some fashion in more of a going concern context, or will it be liquidated through some sort of a fire sale or something in between? So the debate and the fight you can have early on in a case is what is the right valuation methodology for the relevant asset, which can really drive the analysis in terms of determining how much the asset is worth, and therefore figuring out what the diminution in value would be that would need to be plugged. So, in broad strokes, if this is kind of a clear going concern Chapter 11 case and you're marching towards a going concern sale or reorganization, the valuation methodology would be one that'll be focused on what would the asset be worth in a going concern disposition. However, if it's a clear liquidation and the debtor has filed a plan of liquidation or has made its intent clear that's what's going to happen, a liquidation type of valuation methodology would be more appropriate. And we've seen examples where it's somewhere in between, where it's uncertain. You might probability weight what a going concern outcome would look like versus what a liquidation outcome would look like. And the court could ultimately pick something in between. And that's really what it comes down to. It's all in the court's discretion at the end of the day. After listening to the testimony on both sides of a dispute, there's a lot of flexibility in terms of the court selecting what the right approach is under the circumstances.
Great, thank you. And you mentioned testimony. Can companies expect that there will be testimony on these types of issues, and do they need to use experts?
Certainly should, to make the best argument and support as they possibly can, right? It's a very much an evidentiary based type of issue and type of dispute. So depending on some of the factors that I just discussed in terms of what is the asset, what is the hypothetical disposition of the asset that could drive a valuation, your expert, it could be a financial advisor. And if it's a going concern case where the company's throwing off cash during the course of the case, they might put in testimony in terms of what the company's forecasts are. What does the budget look like? What's the business plan look like? So if you measure between the petition date and some point in the future when the case might conclude through a sale or a plan, you could measure a used forecast in a budget to measure what diminution in value might look like. Investment bankers can be great experts as well in the context of a sale process, right? What is the likelihood of a sale closing? What's the likelihood of closing within a range that would peg diminution of value at a certain range that would be used as evidence before the court? And if it's a liquidation scenario and an asset that would be subject to some sort of liquidation process, you might have a liquidator or another expert that kind of has expertise in disposing of that particular type of collateral. So, fact and circumstance dependent, but certainly somebody who has a lot of experience in those types of transactions and can very credibly provide testimony in support of the position.
Great, thanks. So Rob, let's say we get to the point that it appears that the debtor will have to provide some sort of additional adequate protection that's not cash, to use cash collateral. What other types of adequate protection are available?
Well, the debtor can always offer, liens if there are unencumbered assets. The debtor could offer super priority claims for lack of adequate protection. And between and potentially, although pretty rare, they might be able to, provide a priming lien for the use of cash as well. But it's either going to be a lien or a super priority or a high priority claim.
Great, thanks. Can you just give a little bit of background on what a priming lien is and the different, like the priority stack there?
So if you're using the cash collateral of a single lender, then you're not really priming, the single lender, but if there's multiple lenders that have collateral on different types of property, there's potential to offer liens on other creditors property to the extent that you can show that you're adequately protecting their collateral as well. I mean, the easier route to take is if there's unencumbered assets to offer a lien on those type of assets.
Great, thank you. Matt, moving on to kind of the worst case scenario, if the debtor needs to look for new post-petition financing, where does the company look if they need more money?
So a couple of different sources, and some of them are existing lenders. So if you've got a debtor with multiple existing secured creditors, those secured creditors may want to or may be willing to provide additional funding. And there's different reasons for that. Maybe they want to protect the collateral that they or protect the interest in the collateral that they do have by making sure the debtor can continue to operate in that category. I'm thinking specifically of personal property collateral. Real property collateral tends to be what it is, and the real property may not necessarily lose a lot of value, but if you've got personal property that's being used, or in some cases, personal property that is alive. I'm thinking of dairy and farming cases we get a lot of out here. The creditor with a lien on 50,000 sheep wants to preserve the value of those sheep by making sure the debtor continues to operate. So they may be willing to provide some post-petition financing. You may also look to currently unsecured creditors may be willing to provide financing and get a lien on things that gives them a little bit of a bump in priority in that Chapter 11 plan that ultimately gets proposed. So unsecured creditors, or maybe there's also a complete industry of just outside third-party lenders. Every time I file a Chapter 11 case, within a week, I get 5 to 10 emails from DIP lenders willing to talk about potential DIP financing. And so there's an industry out there that the debtor can turn to. I would say, generally speaking, you're probably going to get better terms from existing creditors than an entirely new third party coming in. But sometimes that's the only option. So there's different people the debtors can turn to if they need to.
Yeah,
And
definitely.
I would add something to that.
Yeah,
And
go ahead.
And that is, I mean, a lot of times it really depends on the relationship between the debtor and their primary secured lender. I mean,
Mhm.
sometimes the relationship is so sour that, the lender just wants to kill the debtor, just wants to kill the case, and there's no way they're gonna cooperate in any form or fashion, especially providing, new financing, as opposed to just objecting to the use of cash collateral. Um, I think, I mean, if you go in not necessarily hand in hand, but if you have a strong relationship with a secure lender where there's trust and what have you, your existing lenders, I think, your best source of financing in the case, and in large part because it can really benefit their position, as well. There's things that you can offer them that you can't offer like a third party new lender. And another thing to sort of keep in mind is that if you're in a case and you're representing a debtor and you need to find alternative financing, the code provides that there's sort of like a conceptual or legal cutoff of the existing lender's lien on like new property. So, for example, if you find someone who wants to finance inventory, someone could come in, finance new inventory, get a lien on that inventory. It won't be subject to your existing lender's lien because it doesn't extend to it under the terms of the code. And then that, is their cash and their cash collateral, and you can arrange for its use, going forward. It's rare, but it happens. I mean, a lot of times these cases are filed because some event occurs and you haven't lined up, that financing in advance. And the best you can do is try to use cash collateral just to keep the doors open. But sometimes, as Matt referred to, I mean, once you file a case, you get, dozens of emails from people who are interested in, potentially providing financing for your client.
Yeah, definitely. Matt, just out of curiosity, how do you perfect a lien on 50,000 sheets?
Well, they already had a lien, so it wasn't too hard to protect, but you file a UCC just like you do with everything else.
Okay, good to know. Extra bonus knowledge there. So,
I wonder how
so
you
moving on
inventory.
to dip loans themselves and like presenting the motion. So, Matt, from a company's perspective, what's the company's like main issues in negotiating a debt financing agreement?
From the debtor standpoint, I just need financing, right? Especially
Yes.
if I've already filed the bankruptcy case, I didn't have time to line it up ahead of time. I may be pretty desperate at that point, so I'm not in a real great position of leverage or negotiating strength. Ideally, I get an unsecured loan. In reality, that almost never is going to happen with dip financing. So then the issue becomes, what do I have that I can grant a new lien on? Does it need to be a super priority lien over all the existing liens? What are the different options? But at a certain point as the debtor, I need the funding. So if you come to me and tell me, look, I'll give you funding, it's 22% interest loan. Okay, that may be the best that I can do. Then I got to run cash flow analysis, see if it's even worth doing, or if my only funding option is too expensive, maybe I'm looking at a liquidation plan instead of a reorganization. So I'm getting the best that I can, but I don't always have the best cards to play with.
Yeah, definitely. And as Rob alluded to, does this negotiation typically start like at what point prior to the bankruptcy filing? I know there's a whole range of issues, but if you could just talk through it.
Yeah, ideally the debtor knows that they're going to be going into a bankruptcy case. They may be communicating with the existing creditors. And so you're able to find and negotiate a dip loan moving forward. Sometimes there's competing offers. We had a case last year where there were essentially 3 existing secured creditors. One had a lien on the real property, 2 of them had liens on personal property and the real property. There were dip loan proposals from the 2 personal property lenders, and a proposal from an entirely separate third party that the debtor had negotiated with. There were also intercreditor agreements between all 3 of the existing lenders that caused some issues. And so, ideally you can sort of play those terms off of one another and negotiate the best deal you can find. But as Rob mentioned, sometimes there's an event that happened that triggered the bankruptcy. You got to get it filed, and then you're still talking to those same parties probably, but you're also doing it in the context of, look, I'm struggling just to stay alive at this point. Already got the bankruptcy case filed. There's an urgency now to getting something on file with the court so we can get it approved.
Yeah, definitely. And then Evan, can you walk us through what a lender is typically looking for in negotiating these types of agreements?
Sure. And I think a starting point is just a segue of what we were just discussing in terms of who the dip lender is and what their objectives are, right? If it's kind of a true third party, one of the 5 folks that emails Matt, the moment that they see a debtor is filed, and if they're just interested in some juicy economics and getting a nice quick return on, a limited time frame investment, I think the way they're going to approach the situation is going to be much different than if it's the pre-petition secured creditor. And you're looking at really more from a defensive posture, making sure that your pre-petition claim is going to be kind of poised as best as possible, and that if the debtor needs some cash to get through a restructuring on a going concern basis, you could lend the money from a defensive standpoint and try to avoid a liquidation where your recovery might be worse. And then even kind of further, if it's an insider, whether it's a shareholder, founder, CEO, who may be interested in providing a dip for different reasons, maybe to try ultimately to maintain control of the business or to do the right thing and see the business through a process. Your objectives might be very different, right? So depending on who you are and from a dip lender standpoint and what your objectives are, I think you're going to look at what's important to you differently. But when you kind of think about the full, smorgasbord of protections and asks and economics that dip lenders often seek, at least some version of the sorts of things that stand out in almost every dip facility. Number one, economics. So the interest rate, and for those third parties that are lending into distressed situations, those are going to be high interest rates. I don't know if call it mid-teens, 15% interest range, kind of where things are right now, wouldn't be uncommon. And there's a bunch of different ways to slice and dice economics as well. Like at the interest rate, there's also typically exit fees, unused commitment fees if it's a delayed draw dip facility, usually a work fee or expense reimbursement for the professionals of the dip lender, a breakup fee. So there's a lot of ways for dip lenders to seek favorable economics through a dip facility. Now, in addition to that, in terms of liens, I almost always see things go where Matt kind of got to once you walk through the alternatives. That it's almost always, priming liens and all asset liens that dip lenders will require. You really have to have a situation where there's pretty significant unencumbered assets going into a case. If anything other than that's going to be acceptable to a dip lender. So you usually see those kind of full blanket liens on a priming basis. Dip lenders often want waivers from the debtors on things like the 506C surcharge. So the debtor couldn't surcharge and essentially charge the dip lender for maintaining collateral. You often see marshaling waivers so that the dip lender wouldn't be required to seek remedies with respect to certain types of collateral before going to other types of collateral. And that can be a sticking point with an unsecured creditors committee if they kind of look at collateral differently in terms of what type of collateral might potentially be available to unsecured creditors. And then milestones. Milestones are huge. A dip lender is going to want to make sure that there is a path for them to get repaid. And so whether it's a sale case or a plan case, you almost always see milestones in terms of when the debtor needs to file certain motions, obtain court approval for important parts of a sale or plan process. And there's usually very tight restrictions on extending those milestones. Only you can't without the dip lender's consent. And then last thing I would point out, covenants, kind of going hand in hand with milestones. The dip lender will want to make sure that the debtor is operating the business. If it's a going concern scenario, doing so in the ordinary course, complying with the budget that the dip lender has reviewed and approved, subject to pretty tight variances. So the dip lender will see, look, if the business is falling off a cliff a few weeks in, they'll have an opportunity to see that, decide if they want to try to exercise remedies and call a halt to the process if things are really going poorly. But covenants are awfully important as well. So depending on kind of who you are from a dip lender standpoint, you might be focused on one or more of those sorts of protections and rights. But that's kind of high level, some of the most important ones.
Great, thanks for all that background. So I think in experience, all of these types of things are either negotiated ideally prior to the bankruptcy filing or, in the first couple days after the bankruptcy filing or, right before the first day hearing, if not at the hearing. And then all of that is way before official committee of unsecured creditors is appointed. So Rob, can you walk us through like what happens after the committee is appointed and what unsecured creditors committee is typically looking for in these in reviewing the financing agreement or cash collateral request?
Right. I mean, as you mentioned, I mean, going into a case, you're going to have to use cash or you're going to have to get a dip loan. You always want to go in, not necessarily with the consent of your lenders, but with their knowledge and, sort of work out whatever you can in advance on the use of cash or financing, going forward. And day one, you need to be able to use cash to survive, to make payroll, to operate. So there's not time to to you know to present this to a committee that hasn't even been organized yet, by the U.S. Trustee's office. So fortunately, they've I guess through the rules and the code, they've developed sort of a process for getting interim relief. So you can enter into an agreed order on the use of cash collateral on an interim basis and then set it for a hearing sometime in the future, and afford a committee the opportunity to review sort of the terms and the lender's lien and what you've given up as a debtor to a lender in order to use cash collateral or get DIP financing. I mean, that's almost, that's very typical in a Chapter 11 case. I mean, one of the things, as Evan was alluding to, like the list of things that lenders want, or one of the main things they want to know that they have a valid perfected lien and that you're not going to fight them. So they want those acknowledgments in the order, and they want releases from the debtor, is provided in the order too. On the other hand, the judges and the U.S. Trustee's office, and they want to protect the creditors and the creditors committee and give them an opportunity to review, the extent of the lender's liens, the extent of what they're getting, post-petition, whether it be replacement liens, priority claims, or what have you, in exchange for everything that the debtor's getting. So typically, the first order that's entered preserves those rights of the committee to really, I guess, object to or unwind some of the protections that are afforded to a DIP lender or for lenders who's allowing the use of cash collateral.
Great, thanks. So, Matt, ideally, if a company has more than one secured creditor pre-petition, that secured creditor, regardless of whether or not they're providing financing, hopefully has been involved pre-petition. But if they're not, what issues might a previous pre-petition secured creditor be looking for if they're not involved in the DIP financing negotiations?
So, assuming the DIP financer is gonna receive a priming lien, then the valuation issues, I think, become important. Right, if you're giving a priming lien to this person, but the value of the collateral is then gonna cause some or all of my claim to all of a sudden be unsecured, then I'm making a huge objection, because that drastically changes my position. At the same time, maybe the debtor needs to continue surviving, and so I look at that, but the valuation issues become important. Of course, you still have the cash collateral issues outside of that. If I still have a lien on something and you're using it, I need adequate protection payments. If that priming lien has affected the value of my existing lien, then maybe those adequate protection payments need to be even higher. I also may look at, if there's multiple types of collateral, multiple things that they're receiving collateral on, and multiple existing creditors with liens on different collateral, then a negotiating point may be the marshalling arguments that Evan mentioned before. Maybe I'm willing to not object if you agree that, hey, you're going to foreclose on this thing first, as opposed to something else, and that helps protect my lien position a little bit more. There was a story I was gonna mention. I can't remember what it is now. So, but generally, I'm looking to make sure my position isn't harmed too much, recognizing that getting a priority lien is going to harm my position no matter what. And that honestly is another factor that may influence my decision to be the DIP financiers if someone else is going to come in and get granted a lien ahead of me. Maybe I just don't want that to happen, so I'll match their terms and keep my lien.
Sure, definitely. Evan, Rob, anything to add to that, or any interesting stories about your representation of one of these constituencies in a bankruptcy case in your experience negotiating DIP financing?
I'll share one story that comes to mind, which is kind of funny in a way that it was a debtor with an ad hoc group of note holders and a sponsor shareholder, right? And the only asset the debtor had were shares in an operating company. So the debtor needed funds to get through a case. So the only asset to pledge was the shares in the operating company. There was going to be a big dispute over what the value of those shares were. And that dispute, everyone knew was coming. And the company didn't need a lot of, it wasn't a huge DIP loan, but it was something like 15 or $20 million to get through this process. And so you had competing proposals from the shareholder and from the ad hoc group for the DIP. And they, certainly didn't trust each other. They wanted the liens on the shares in the operating sub. And we represented the debtor in this case. And so what started out with your more typical, especially from the ad hoc group, a very expensive DIP financing proposal, they just started competing against each other to bring down the economics, because what they really wanted was just to have the lien on the shares in the operating company. So if things went south, they'd be able to take the asset. So it ended up being a very competitive bidding around the economics, and I forget exactly what it ended up being, but it was like 1% or like 1.5% DIP interest rate, which the judge was very pleased with. So were we, but it was I've never quite seen that before. The economics just flew out the window. All that mattered at the end of the day was parties wanting to have access to the underlying assets, and ultimately I think the ad hoc group got down low enough and won the race to the bottom.
Wow, that's a better interest rate than my mortgage.
Maria, I remembered the one other thing I was going to say too. I had a case where the existing lender, so the debtor got approval for a $45 million DIP loan, but the existing lenders were able to convince the court to authorize the loan, but not authorize all the draws on the loan. And so the court basically said, look, I'll let you draw 5 million at a time. You have to come back to me each time and request that draw. And that was the way that the existing lenders were able to sort of monitor as it went on the cash flow from regular cash to determine, hey, look, do you really need the 45 million, or is this just, belt and suspenders that the debtor and the DIP lender negotiated? And as it turned out, I think the debtor only ended up borrowing about 22 million off of that $45 million loan. So that's another sort of control that the existing lenders might be able to put in to help minimize the impact of that post-petition financing if the debtor's cash flow is able to actually to succeed.
Yeah, definitely. We were involved in a case last fall where we were representing a committee and then backed off of the DIP negotiations where once it was clear that the debtor was not going to need the DIP at all, even though they had requested full approval. So, it just wasn't worth the squeeze there. Rob, anything to add there?
I mean, the only thing I would add is in getting back to like committees. So, I mean, oftentimes when you're the lender and you're negotiating, the use of cash collateral or post-petition financing, and you're going head to head with the debtor, you may lose track of the likelihood is at the end of this case, it's going to be you and the committee, because the debtor is going to be, not operating anymore, because sadly, that's how most cases go. So I think as an attorney for the committee or for the lender, even for the debtor, just keep in mind, to try to maintain, positive relationships, if nothing less, with all the constituents involved in the case.
Yeah, that's a great perspective. And I represent a lot of borrowers and debtors and companies, and it's certainly the approach that I tried to take is, we call ourselves kind of the honest broker, right? We're here, we have a lot of, disgruntled stakeholders for very different reasons with very different objectives. And we're gonna have very different stories coming from different angles, right? So our job really is, a debtor counsel role is to, get everyone at the table, have an understanding of the facts, understanding of rights and entitlements and risks, right? And try to get to a point where you can essentially strike deals to get through a case and try to avoid, what ends up being a very value destructive litigation situation if you can't do that.
Yeah, because often the debtor can't afford to really litigate these issues to the ground.
Right. And I think like at the end of the day, like when the case, kind of dwindles down and you're representing a lender, and you have a claim for lack of adequate protection or diminution in value, I think that's probably one of the most difficult things to prove. And and it largely depends on sort of like what's provided for in the in the orders. You got to be very careful and try to simplify it. If you're a lender, you want to simplify it to the greatest extent that you can as far as quantifying. And if you're the debtor, you want to probably leave it loose and and left to interpretation, by the courts.
Yeah, definitely. Okay, switching gears a little bit. In some more recent cases, there's been kind of a trend toward like more purchasing secured, like a party, either an outside party or another lender purchasing the other pre-petition secured debt and then also providing the loan or doing both in some combination, however. So, Rob, can you walk us through the advantages and disadvantages of that type of scenario?
So I think the main advantage of purchasing the pre-existing debt and liens is that if you can provide post-petition financing, and you can try to have the use of cash collateral or the use of sale proceeds applied to your pre-existing debt, and then your post-petition debt is not only secure, but the extent it's not secured, it's an administrative claim. So you sort of in a roundabout way, you're taking your pre-petition claims and you're sort of making them post-petition claims. And I think that, to the extent that, you have someone interested in lending, and they could, become the senior secured, and the pre-petition, claims are properly, secured and perfected, that could put them in a better position as well.
Yeah, definitely. Okay, great. And then, Evan, another scenario that is sometimes seen is like what's called a loan to own DIP loan. Can you explain what these types of DIP financing loans are and how like this type of lender's motivations may differ than a traditional DIP lender?
Yeah, and back to the always asking the question, what's the objective of the DIP lender, right? So here, if the DIP lender, whether they were a pre-petition creditor or not, if their objective is to own the business or the underlying assets, they'll structure their DIP loan in a way that makes sure that they have a good shot at doing that. And there's a couple ways you could structure it, and ultimately it's through one way or the other converting that DIP loan into an ownership interest or ownership right with respect to the assets. They're gonna have two primary ways to do it. One would be through a 363 sale, and the other would be through a plan of reorganization, where from the get-go, the DIP lender would kind of put into the documents, and back to milestones too. Very clear 363 sale milestones or very clear plan of reorganization milestones. And if they have enough time, right, and they've wrapped it up, really buttoned it up with the debtors in advance of filing, they might have fully negotiated a stalking horse purchase agreement or a plan of reorganization where the DIP lender is the plan sponsor, both having the same ultimate objective of either through a sale where the DIP lender could credit bid, use its DIP as currency, or through a plan where the DIP loan would convert into equity of the reorganized debtors. The DIP lender ultimately comes away as the owner of the assets. If you're a DIP lender, there's some pros and cons to those two approaches. The 363 sale approach might be able to go more quickly, because you wouldn't need to go solicit creditor votes. But on the other hand, the 363 process typically is more of a public process that there could be a greater likelihood that other bidders would come in and potentially submit competing bids against the DIP lender's bid. In the plan scenario, it might not need to be as competitive. It could be structured as, hey, here's the plan sponsor and here's the plan, vote yes or no. But then you would probably, unless it's a pre-pack, you'd probably have to wait and have an unsecured creditors committee formed. Might have some deals you would need to strike before getting certainty that your plan would work, or potentially have to deal with a contested cram down confirmation hearing. So different dynamics and pros and cons to those two approaches. And then the last kind of flavor of those that I'll point out, which we've been seeing more frequently, is this idea that there'll be a DIP loan, not as fully baked as those two scenarios that I just described, but the DIP loan would say that it either at the DIP lender's option, or it could be required to be repaid not in cash, but in equity of the reorganized debtors. So similar to the plan approach, but not fully baked yet. But basically asking the court, right, at the beginning of the case, before a plan has even been drafted, let alone solicited and confirmed, but hardwiring in a use of an issuance of reorganized equity, right? And that's usually there's economics around that too. It's at a discount to plan value. Well, there's no plan value yet because you haven't gone through confirmation, but it's a creative way for DIP lenders to really try to hardwire in a loan-to-own strategy at the beginning of a case without having fleshed out the full plan process at that point. And those, look, these structures have certainly been criticized as sub rosa plans, or if a shareholder is involved, violating the absolute priority rule. In some instances, they've not been permitted. In other instances, they have, or they've led to laid the groundwork to reach settlements with other relevant stakeholders. But point is really you can be creative as a DIP lender when it comes to how you want to try to achieve bigger picture strategic objectives, though not without risk. And these approaches can be controversial.
Great, thanks. Matt or Rob, any other trends that you've seen or any other creative solutions?
I haven't seen anything different than what I already talked about.
All right, and then just lastly, we've talked overall about like the general goals and objective of a DIP lender and a company, and then the various other constituencies. Can one of you walk through just procedurally how a debtor goes about getting the approval for the use of the cash collateral and the DIP financing at the beginning of the case, like what's involved procedurally?
So I can take that first, I guess, and then let others chime in. It's usually the debtor seeking it, so the debtor prepares and files a motion. Depending on the urgency, there may be an interim hearing and then a final hearing later, depending on the timing of the motion too. If it's filed before, if it's filed in a case where there likely will be an unsecured creditors committee, then usually the court's going to want to provide that committee time to get formed and then jump in and respond. So you'll have an interim process with maybe an interim order authorizing some of the borrowing, but then a final hearing later if the timing requires immediate funding. But it's a motion, the proposed loan agreement and security documents and et cetera are usually all attached to the motion, so parties know exactly what all the terms of things are. And then just like any other motion, anybody can object, can request modifications to the forms, that sort of thing.
And if it is a scenario where it's a contested use of cash collateral, right? If you don't have a deal, if the company doesn't have a deal with its secured creditor and it's going to the judge and asking for non-consensual use of cash collateral, which is about the most aggressive, and roughest way to start a case as possible, but sometimes you just have to. that can lead to some of the most expedited litigation that really the bankruptcy process has to offer, just given how important it is to the survival of a business to have access to cash, and how critical it is to the secured creditor that its cash collateral isn't used improperly. That you can see, some very, very short time periods within a week or 2 weeks, a judge could set a schedule where depositions, discovery would all need to be done, be back in court, putting on expert testimony, the litigation strategies fully evolved and ready for prime time in a very, very short period of time. So it's just if it ends up on that side of the equation, it can be certainly a lot of fireworks at the beginning of a case. And the bankruptcy courts are often, very willing to accommodate that tight timing, just given how important the issue is.
Yeah, definitely. We sometimes have our litigators help us out with those types of situations, and our litigation colleagues are astounded by the speed at which things are expected to be done sometimes. We have a deposition notice like 2 days, 2 days from now or whatever. And you just got to do what you can to, get it done and do the best you can. So, all right, unless I'm not seeing any questions or anything, anyone else wants to add to this subject?
I mean, along those lines of the cash collateral motion, I think it's very important to familiarize yourself with your judge's emergency motion procedures and get those right. I mean, while they're mostly willing to expedite and have a hearing on short notice, some of the judges and clerks are very persnickety about the procedure, so you got to make sure you get that right.
Yeah, of course, the last thing that anyone wants is for something to be thrown out or not approved just because of some procedural or administrative matter. So that's a great point.
Yeah, and I'll echo the judges. If there's some urgency, they'll make time. I've had a couple of cases where, we filed the case on a Friday and had a hearing Monday afternoon on the initial motions, one of which was the DIP motion. So the court in essence did 2 interim hearings. So you had the hearing the Monday, one business day after the filing, and had another interim hearing a week later, and then a final hearing about 6 weeks after that. So they'll make time if there really is truly urgency, and you can convince them of that. They'll adjust their emergency procedures if they need to. I will say one other thing too, when it comes to sort of the creativity of stuff. Most of the time, these DIP lenders are going to be granted an administrative priority claim as part of the negotiating, which from a plan perspective and a confirmation perspective usually means it's got to be paid off on the effective date of the plan, especially if they're given a super priority liens over everybody else. I'm involved in one case where the DIP lender's loan documents allow, and these are the documents that the court approved, allow that DIP loan to be converted into exit financing without additional financing being provided. But in essence, with the DIP lender's approval, the debtor can propose to pay it over time rather than as an administrative claim on the effective date. And that was triggered in that case, and that's what the plan proposed, was essentially a 2-year repayment period for this DIP loan, which the lender consented to, so it wasn't an issue of administrative priority and effective date payment. The other secured creditors really didn't like it because their assumption at the beginning was, hey, once the plan's confirmed, then we're back to our original lien positions. But because the loan documents had allowed it, that they all had approved in negotiating the DIP financing, the court essentially told them, look, you guys consented to this when you agreed to the loan documents that allow it. So you can get creative if you need, from the debtor side, if you need the flexibility later. Of course, the DIP lender can always say, no, I want to be paid on the effective date, or I'm out. So it just, we get paid to be creative as attorneys, and sometimes it's worth exercising those skills.
Yeah, definitely. All right, well, thanks to each of our panelists today, and thank you for joining us for this webinar. You can find the slides attached to your program, and then there's more information throughout there and also about us at the end, and then financial voice at the front. And thank you all for joining us.
Thank you.
Thank you.
Thank you.